Appeal number 78, matter of estate of Hennel. Counsel?
Your Honor, Peter Coffey, Engler Coffey McHugh in Schenectady, New York. I represent the estate. First of all, if you're going to have promissory estoppel, you have to have a promise. It's all over all the papers. If you want citation, it's Rogers versus Islip. To establish a viable cause of action, some sounding in promissory estoppel, there must be a clear and unambiguous promise.
Counselor, the appellate division indicated that you had conceded that there was an oral agreement. Is that not
Well, that's
accurate?
not true. And I don't know where that's gotten, because I brought my briefs from the other court. We've always challenged that.
Okay, so you don't even concede that there was an agreement between the decedent and the grandchildren that he would transfer this property to them mortgage-free?
There was conversation, apparently. But if you listen to Mr. Parisi, he says, that's what they told me. And he said, I don't know what was in the decedent's mind. The petitioners say they had conversations. So there may have been some conversations, but there's nothing particular.
But is that corroborated by the fact that there was a deed?
No, the deed simply gives a life estate. He gave them the property. He gave them the property.
Let's clarify this. You said the deed gave him a life estate.
Yes.
Is it, what kind of fee is actually transferred? What fee estate did they get through this deed?
In that situation, you have
Based on the language of the deed.
You have a conveyance of remainder interest and the reservation of life estate, and also the reservation of power of appointment.
So what does it mean in the deed where it says, reserving, however, to the grantor here in a life estate an exclusive ownership? What does that mean? So during the life estate, what did they
During
get?
a life tenant,
Yes.
has exclusive possession of the estate.
No, I understand that. It says possession, but it also says ownership. So I'm actually not even sure what is actually transferred to these people.
Well, it's a life estate. It's clear.
He's retained a life estate, I get that, but what
Yeah.
has he actually conveyed? Is it a fee simple absolute subject to this life estate? What is he actually?
Yeah, exactly.
Okay, with the
exactly.
power of-
It's subject to remainder interest, EPTL.
All right.
Exactly, you're absolutely right. It's a fee simple, subject to fruition, if you wish.
Yes.
Yes,
Okay,
exactly.
thank you.
Now, and it's a life estate with power of appointment. It's all ambulatory. He can change these people, and of course they did some work and they took care of the property. Why? Because if they didn't, he could appoint it to somebody else. Now, the
So
point.
I know you want to talk about whether there's an agreement, but
Yeah.
the appellate division
Yes.
seemed to disagree only on whether it would be unconscionable not to uphold this agreement and to apply the statute of frauds.
No.
Isn't that what the appellate division said?
No. The appellate division in the dissent, okay, says, it bears specifically noting there was no evidence of a decedent expressed any such promise in any form.
Slow down.
Yep.
That's not the point. The point is that the majority holding is a little different, though, right?
The majority, yes, the majority says this on that issue.
No, you don't need to read it to me. I've read the appellate
Well,
division. Slow down. I've read the appellate
You
division.
got it?
Yeah, thank you. Rather than concentrating on whether or not the wrong procedure was looked at and whether or not there was a change in the 2006 from 2008, I think the question of unconscionability is really what we should be talking about. Two things. First, whether or not this court should adopt the promissory estoppel plus unconscionability exception to the statute of frauds. I'd like you to concentrate on that, if you would, address that argument. And if we should, was this an unconscionable change from the 2006 transaction to the 2008 transaction? Go ahead.
It has been suggested, says Mandel versus Liebman, that an unconscionable contract is one such as no person in his senses and not under delusion would make on the one hand, or an honest and fair person would accept on the other. Chancellor Kent must be the inequality must be so strong and manifest as to shock the conscience. Now, what happened here? What happened here? These petitioners got a piece of property worth $250,000. There's a $90,000 mortgage. Now, constantly, everybody's saying they took on debt. They didn't. General Obligations 5705 was not in the deed. They didn't assume the debt. They could have walked away and not had a penny and no liability and no responsibility. They assumed no responsibility whatsoever. None. They could have sold the property, the decedent's death, and pocket.
So you're saying they got something, they don't have any
They got
debt,
150
and
I'm
it's
sorry.
not unconscionable to deny them the additional property interest that they want. That
Exactly.
is the payment of the mortgage.
Exactly. They got $150,000.
Why isn't the mortgage a debt of the estate?
Pardon?
Why isn't the mortgage debt, a debt of the estate?
Because the cases hold it's not. It's outside the estate. The estate, it's not.
It's a personal loan taken by Mr. Hennel, right? Which he's obligated to pay. And the surrogate's court found that it was a just debt of the estate,
I'm sorry, the surrogate's court found what?
that it was a just debt of the estate.
Yes, but the appellate division said that that only applies if it's a just debt, and it is not a debt of the estate. So they assume no responsibility for the debt, no responsibility. And I'll be honest with you, Your Honor, we cited a case in the lower court. We've cited it here, and it's not coming to me right at the moment. But there's an appellate case saying that a debt such as a mortgage applies to the property and not to the estate. I don't have it in my mind right now, but that is the law.
Is that because he transferred that conditional fee absolute? Well, not absolute.
No,
Is that because he
no.
transferred the fee, not because of the fee transfer? So the
Pardon?
mortgage is not part of the fee transfer, is what you're arguing?
No, it's not. A mortgage, if you look at the real property law, a mortgage does not affect marketability of title. A mortgage is a lien. And I can't come up with the case right now, Your Honor, but in fact, it is not. It's a mortgage, it's a lien on the property, which is satisfied out of the property, not out of the estate. That's the law. Now, I see I've got much time left. If you look at the case cited by both the majority and the dissent, and they had a woman there who lost $100,000, lost her life savings, lost her child's college thing, had her college fund for her son, had to sell her car to pay her debts. That's unconscionable. These people, there's nothing unconscionable about this debt, this thing. They spent a little extra time, and one was Smirnoff. Smirnoff is a case cited by everybody, and that says right there, the spending of a little additional time does not render a deal unconscionable, and that's all they did. They spent a little extra time.
Mr. Coffey, I took the liberty of reserving 2 minutes of rebuttal time for you, if you would like it, after your...
Thank you, Your Honor. Thank you.
Good afternoon. Robert Adams, Martin, Schutt, Wallace, DiLorenzo, and Johnson, attorneys for the respondent on this appeal. I will, of course, as you've suggested, focus on the unconscionability issue first. I think that there are two things which make this case uniquely unconscionable when you look at the sequence of events. When you start off with a promise which was made by Edmund Hennel to his grandchildren.
Don't we have to look at what the outcome was?
I
I
think
have a
that,
hard time thinking that this is unconscionable when they didn't expend any of their own money. They did for 4 years collect rent and do some other things, and for that, they end up with a piece of property worth approximately $150,000 after the mortgage is paid. What's unconscionable about it? Maybe it's not fair. Maybe it wasn't the bargain they thought that they had made. But isn't that different from saying that it's unconscionable?
I think if it was only a mathematical issue that made something unconscionable, I'd have to agree with you. But in this case, that's not the situation. What's unconscionable here, Your Honor, is that there was a promise. My clients performed their promise to a T. They did everything they're supposed to do. And the understanding clearly was, and, I think we don't have to spend a lot of time on the fact that there was a promise, but if you look at
Well,
the record.
don't both parties concede that promissory estoppel applies here?
Well, apparently not as of today. So I think I just need to mention that certainly the record is very clear that there was a promise. I note that in the context of a summary judgment motion made by my clients at the trial level, the opposing papers did not present any evidentiary proof to rebut
I don't want to get you off too far down.
I will stop with that.
I don't want to
so we
get you
move
off
on.
too far on
Sure.
another track.
So I'll
but-
get back to my points of what's unconscionable about this situation. So my clients lived up
Before
to
you
the...
do that, I'm really sorry, but
okay.
I should have made sure that we were on the same page. Do you agree that it has to be unconscionable in order to offset the statute?
I think the statute is, I think the case law is pretty clear that the word unconscionable, which of course is very subjective,
Okay.
is a standard that we have to meet.
Okay.
And I think that you can't look at it and say, well, they got 2/3 of a loaf, or they got half a loaf. It's got to be more than that before it matters. I think if you take a rule like that, I think, you're
I
taking all
guess,
the
though,
meaning out.
the question is, while this may have been unfair, it would seem that every instance where promissory estoppel applies would now be a exception to the statute of frauds if we adopt your particular argument. So why don't you address that?
Sure, and Your Honor, I'm going to get back to what I was saying before, because I think there are two factors here that are very unique and make it unconscionable. The first one is this, that if they were to get the benefit of the bargain, my clients would have to end up owning this property. That's what the bargain was. They're supposed to own it free and clear. If they've got to pay the mortgage, they're not getting the benefit. And if they were to pay the mortgage and adopt and keep the property in that fashion, they would essentially be funding gifts made by Edmund Hennel to 4 other family members.
Yeah, I looked at that argument, and that's the argument that says he gave them $100,000, and then the money was then used to fund a golf course business, right?
Correct. Well, it was used, actually, no, it was used as a gift to a variety of family members. They, in turn, invested in the golf course, and then 4 people had a falling out and got paid. But that's not the biggest issue here, Judge, in terms of unconscionability.
Go ahead.
That's kind of the appetizer.
Go ahead.
Okay? The real issue here of unconscionability is what happened over time, because Mr. Hennel, Edmund Hennel, makes the promise. He then proceeds to have them perform, and then, in 2006 is the promise. 2007, October 22nd, 2007, he makes a new will with a new wife, and that will is deemed to have revoked his promise in some
Okay,
fashion.
but when we talk about unconscionability, aren't we talking about injury? Isn't,
I think
so what happened, you're saying that the process was unfair. I think that's what you're saying. But don't we have to get to the final analysis, which is, what did these people lose?
Sure. Well, two parts to that answer, if I might, Your Honor. The first part is that what was unconscionable wasn't just that he did create the new will. The record clearly establishes that he spoke to both of my clients and told them, oh, I did a new will, but nothing changed about the property. Everything's good. He reassured them falsely.
What if the value of the property since then had gone up threefold? And now they didn't expect that to happen, but something happened in Schenectady and the property values went through the roof, and now this property is worth way more than they ever thought it was.
And I think that goes to the point I made before, that I don't believe that the way in which to evaluate unconscionability is whether it was a good deal, a bad deal, a winner or a loser. I think you have to look at what were the external circumstances that would be sufficient to shock your conscience.
But now it sounds like what you're saying is the shocking of the conscience is the fact that their grandfather didn't do what he promised them he was
Right.
going to do.
He lied to them.
Doesn't that get back to, he broke a promise and we sort of lost unconscionability? Because what you're saying is unconscionable is the breach of the promise.
But it's more than a breach of the promise. It's basically fraud, because he got them to continue to perform all their duties. He continued to live there.
Well, fraud would be if they weren't compensated at all, and if he did it with malicious intent. I think we're a long way from fraud here. If somebody, my grandfather gives me a piece of property, instead of getting $230,000, I got $150,000. I don't know if that's fraud.
Well, he certainly induced them to continue doing something which he knew from having signed the new will, he was no longer going to perform his side of the deal.
Let me ask you this. What would be the standard that you would ask this court to adopt? Because it seems like you're asking us to change the unconscionability standard. Are you asking us to do something new, something other than shocking to the conscience or that line of cases?
No, I don't think so, Your Honor. I think that it does shock the conscience to think that someone would induce somebody to make a deal, induce them to take over all the obligations.
You haven't
and
been
then
in
walk away.
courts that long then, if you think that, because we both experience, I think, in courts, and in courts that happens quite often, then business transactions, people disagree in the meaning of what they've done.
That may be, but they don't typically tell the other side in a bargain, by the way, everything's fine, I haven't made any changes, and in fact, they've pulled the rug out. I think that's a very distinguishing fact in this case, which falls within, in my estimation, shocking the conscience or unconscionability, because you shouldn't be allowed to induce someone to continue to perform at a point where they could not mitigate their damages, they couldn't stop. They continued working on this up until the time of his death, and only upon his death did they, for the
If
first
before
time, learn
his
of this.
death, he had actually paid off all but 1% of what remained on the mortgage, is it still unconscionable?
Well, we're back to making it a math problem
No,
again,
but
Your Honor, which I think is
I'm asking
difficult.
you.
Sure.
Because you
I
take
think
the
that's-
straight line that it's the
Sure.
breaking of the promise.
Well, I think that it's a breaking the promise plus damages. And one of the things I'd point out is that in this case, again, in the context of a summary judgment motion, the other side did not do anything to say that, oh, by the way, in their opposition to summary judgment, they didn't come forward with any proof saying, oh, well, you know, the work that you did was only worth this and you got this much of a return on your dollar for all your work and effort. None of the facts were opposed in the summary judgment motion on the part of the estate. So I think we have to accept as true the things that were said, which was that, indeed, they did put a lot of effort into it. There's an attempt to minimize it, but
Well,
the
that's an
record...
interesting question, too. Where's the burden? I mean, you're essentially trying to overcome a statute of frauds defense, so don't you have the burden of showing that it was unconscionable? Don't you have the burden of showing what the value of that work and those efforts were?
Well, I don't know that the burden comes down again to saying, here's how many dollars it was worth, but there was very extensive proof put in sworn form as to all the different things that they did, all the benefits that their grandfather obtained from their labors, and...
Right, and that
was not contested.
proof wasn't opposed, but we don't know what that translates to, right?
Well, I think we know the various pieces of their performance which they had to do in order to keep their side of the bargain. And I think, again, the unconscionability, and I realize I'm down to my last minute here, so I'll just say that I think the unconscionability comes into inducing the clients to continue at a time when you knew full well that you had now made a change. And I don't think that any of us feel that it's fair, reasonable, and therefore not unconscionable to induce someone to continue to perform when you know full well you're not going to keep up your side of the deal. I think that
Can you
does shock
help me
the
on
conscience.
my just debt of the estates question? The loan and the mortgage are two different things in my understanding, right? Mr. Hennel took out a loan and it was secured by a mortgage.
Correct.
Why isn't the loan an obligation of his that is then an obligation of his estate?
Right, and I think the reason why that would be accurate, Your Honor, I would agree with it, because the use for that money was not to be put into the Franklin property. It was to be...
Regardless
used
of
as
the
a gift.
use.
Right, so it wasn't
Regardless of the use.
associated with the property. So I think it is a debt of
And
the
if
estate.
that's right, then why would you draw the conclusion that when he changed his will, he actually changed anything about his obligation to pay the mortgage?
Well, I think because I wasn't counting on the concept that a court would agree with that. Obviously, there's
Well,
been
the Circuits
disagreements.
Court appeared to, unless I'm misunderstanding it.
I think they did, but certainly the focal point was on the statute of frauds issue, so hence the focus now on it as well. But I don't disagree that if it's deemed by this court to be an estate debt, then the issues of unconscionability, frankly, don't have to be resolved.
Thank you, sir. Counsel?
Thank you, Your Honor. I can't find it in my papers. It's clear, though, a mortgage on property is not an estate debt. It's a lien against the premises, and is not paid out of the estate. It's paid out of the mortgage, out of the property.
That's the mortgage, that's
And at
not
the
the loan
estate-
instrument.
Pardon?
They're two separate documents, right? There's a loan agreement and a mortgage.
Right.
The mortgage is recorded, the loan agreement is between Mr. Hennel, presumably, and the bank.
Well, no, the mortgage is security for the loan.
Right, it's security for the loan, it
Yeah,
isn't the
so-
loan itself.
But it is a lien against the premise. Anyway, I don't want to go too far, but the law is clear that mortgage is paid out of the property, not out of the debt. We have Rock v. Rock, Second Department. A man moves in with his parents. He spends $178,000 over 20 years improving the property. The Second Department held promissory estoppel didn't apply. In the case of Fleet Bank versus Pine Knoll, spent $100,000, lost her son's savings. That was promissory estoppel. As far as unconscionability goes, the case is, oh darn, I had my number on. Anyway, Smirnoff says, and very clearly, that spending a lot of extra time doesn't count. It's not unconscionable. And that's the only, Smirnoff, that's the case. Time doesn't count. And guess what? That's the only thing the petitioners did here. The only thing. They only spent a little extra time managing the property.
So if
And-
they actually had to pay for anything as part of that
They didn't have to
management,
pay
would
for
it be
anything.
unconscionable? Well, I understand, it's a hypothetical.
Right.
I'm asking.
Okay, yes. I'm
Yes,
sorry.
if they actually had to pay for any maintenance of the property, would that then have made it unconscionable?
Well, I don't know, Rock v. Rock says 100,000 doesn't count. If they paid a little maintenance, I don't think so, Your Honor. But in fact, the point is, this property is self-sustaining. And I know there's a question about future and whatever, but to answer Your Honor's opinion, if they held on to this property, now I know property is not appreciating very well, but it's appreciating somewhat. If they held on to this property for 10 years, they would have it totally free and clear, $300,000, and they'd walk away with $300,000.
Couldn't they sell it
Pardon?
now? Couldn't they sell it now and walk
Right
away
now.
with money?
Right
They
now,
wouldn't be in debt.
pocket the money.
Can I ask you, Judge, if it's all right, just, I see your time's almost up.
I think
For
it is.
you to be successful, we have to recognize for the first time the doctrine of promissory estoppel applying here, and then make a determination as to whether or not that violation of that doctrine was unconscionable. So there's a case, Cohn versus Brown, Harrison, Stevens, are you familiar with it?
No, I'm not.
All right. The appellate division makes reference to it, though they don't quote any language from it. But, all right, if you're not familiar with it, I'm not going to ask you about it. Thank you. No, I just,
No, I'm not.
no, it's all right.
Thank you, counsel.
Thank you.
It's okay.